Good afternoon and welcome to the Cato Institute. My name is Tim Lynch and I'm the director of Cato's Project on Criminal Justice. This afternoon we are celebrating the publication of two new books. The first book is Go Directly to Jail, The Criminalization of Almost Everything by Gene Healy. The second book is called Constitutional Chaos, What Happens When the Government Breaks Its Own Laws by Judge Andrew Napolitano. Now, I think that this is the perfect time of year for these two particular books to be published. December and January are the months of the year when many of us kind of take stock of the year that has just passed and make plans and new goals for the upcoming year. And that's essentially what we want to do today, but on a much bigger subject. What we want to do today is take a few steps back from the news of the week, such as how the war is going in Iraq, the speculation over who President Bush might appoint to head the Department of Homeland Security, and to assess the state of freedom in America. I've been in Washington for 15 years, and I can tell you that the Congress has never convened a hearing on the state of freedom in America or how well the Constitution is doing. But that's why it's great to work for the Cato Institute, because we often raise subjects that the politicians would rather not discuss. Now, I should say that these two books carry a message that many people do not want to hear. Both books demonstrate that America is drifting away from the principles upon which this country was founded. That's the bad news. The good news is that these two books are calling attention to this problem, and that's the first step towards correcting it. Now, enough from me. Let's turn now to our featured speakers and see what they have to say. We're going to begin with my colleague, Gene Healy. Gene is an attorney and senior editor here at Cato. He edits our policy studies and book manuscripts, but he also has his own research interests and does his own research and writing. His primary research interests include the criminal justice system, the constitutional principle of federalism, and the constitutional parameters on the war power of our government. Gene earned his law degree from the University of Chicago, and then he practiced law for several years here in Washington before he joined the Cato staff. For the past 2 years, he has been focusing his attention on the creeping expansion of the criminal law, both at the federal level and at the local level. And as I said, his new book is entitled Go Directly to Jail, The Criminalization of Almost Everything. Would you please give a warm welcome to Gene Healy?
Thanks, Tim, and thanks to all of you for coming out here today. Judge Napolitano is going to talk to you a little bit about how the government doesn't have to follow its own laws. I'm going to talk about a topic that's just as frightening, the laws that the government expects you to follow. They become increasingly punitive, arbitrary, and bewildering. And that's due to three dangerous trends that are transforming the criminal law. The first is overcriminalization, the expansion of the criminal law to cover behavior that really ought to be handled by civil lawsuits or fines, or even to cover behavior that's just none of the government's business, period. The second is the out-of-control federalization of ordinary crime that the Constitution leaves to the states. And the third is the use of criminal law enforcement tactics, that is, handcuffs and jail, against ordinary nonviolent citizens who aren't crooks or thugs. Now, in a free society, as a preliminary matter, there ought to be very few offenses for which you can be locked up and taken to jail. Those offenses ought to be clearly defined. You ought to be able to look them up. And they ought to be limited to the kinds of behavior that we'd all recognize are the sorts of things you can rightfully lose your liberty for. Killing people, stealing from them, assaulting them, defrauding them. Serious matters. That's not the system we live under today. Over the past several decades, there's been this sort of unholy alliance between, on the one hand, tough-on-crime conservatives and, on the other hand, anti-big business liberals. And this has utterly reshaped the legal landscape. The result is that while violent crime often goes unpunished, you see Congress continuing to add these new trivial offenses to the federal criminal code. It's become, in a way, just another form of self-expression for Congress, a way to show that it's serious about whatever the given social problem of the month is, whether it's corporate scandals or steroid use. And the upshot of all this is it's now frighteningly easy for American citizens to be hauled off to jail for things that no sane person would regard as a crime. As Harvard law professor William Stuntz puts it, we're coming ever closer to a world in which the law in the books makes everybody a felon, and prosecutors and police get to define what the law on the street is and decide who has violated it. There's a famous speech warning about that some years ago by FDR's Attorney General and later Supreme Court Justice Robert Jackson. And when Jackson started as Attorney General, he called together all the federal prosecutors and said, he gave them a speech warning about the temptations of their job. He said that with the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. The great danger, Jackson said, is that he will pick people that he thinks he should get rather than pick cases that need to be prosecuted. Well, that danger's gotten dramatically worse. When Jackson gave that speech, the body of federal criminal law was less than half the size it is today. Today there are around 4,000 crimes scattered throughout the tens of thousands of pages of the United States Code. I say around 4,000 because nobody's really sure. There are teams of expert legal researchers with a lot of resources from places like the American Bar Association, the Federalist Society, and the Congressional Research Service, and they've tried to count them, and they can't come up with an exact number. It was too complicated a task to figure out what was a crime and what wasn't, which means, of course, that the ordinary citizen doesn't have a chance. As you might expect, all of this happened in clear violation of the Constitution. There are only 3 specifically enumerated crimes in the Constitution: treason, piracy, and counterfeiting, none of which Martha Stewart was accused of. From that sort of narrow grant of criminal jurisdiction, you get a sense of what the Constitution was supposed to focus on and what the scope of federal criminal law was supposed to be. It was supposed to deal with big national issues. The federal government was never intended to have a general police power, but it acts as though it does. Federal jurisdictions expanded to include a host of crimes that are already illegal at the state level: drug crimes, gun crimes, robberies, car theft. Almost anything short of jaywalking can be made into interstate commerce and prosecuted federally. Now, on top of that comes a host of crimes that barely pass the straight-face test. It is a federal crime to deal in the interstate transport of unlicensed dentures. You can get a year in jail for that. You can go to prison for up to 6 months for pretending to be a member of the 4-H club. You can get 6 months for misappropriating the character Woodsy Owl or his associated slogan, "Give a hoot, don't pollute." It is a federal crime to disrupt a rodeo. Now, I yield to no man in my desire for orderly rodeos. But why on earth is this a federal issue? And you look at some of these crimes and you can picture the awkward conversation, in your head with your cellmate. What are you in for, kid? But overcriminalization, it would be a lot easier if all of this was just a laughing matter, if it was just a few ridiculous crimes or some violations of federalism. And I wish the problem was limited to that. But it's actually much more serious. It's also laws that sweep far too broadly. For example, most people think that Martha Stewart is in jail for insider trading, but that's not the case. She wasn't even charged criminally with insider trading. They knew they didn't have a case against her for that. Instead, she was sent to prison for attempting to cover up something that wasn't even a crime. She's convicted under an insanely broad statute covering misrepresentations to the federal government. Now, under this statute, 18 U.S.C. 1001, you don't have to be under oath. The federal agents don't actually have to be misled by the misrepresentations. They don't have to give you a warning, and it's perfectly okay for them to lie to you. The statute applies to, quote, any matter within the jurisdiction of the executive, legislative, or judicial branch of the United States, which, given the expansion of federal jurisdiction to cover virtually any area of American life, is pretty broad. The statute even applies, amazingly enough, to protestations of innocence. There's a 1998 case where the Supreme Court got rid of what's called the exculpatory no doctrine. And what that means is that even if all you tell federal investigators is, I didn't do it, and you did, you can go to jail for up to 5 years for that misrepresentation alone, even, as the Martha Stewart case shows, if what you said you didn't do wasn't actually a crime. You can also go to prison for mere negligence. Historically, to lock somebody up, you have to show criminal intent, what Blackstone called a vicious will. But today, we too often send people to jail for making mistakes or for not understanding the staggeringly complex regulations that business people operate under today. For example, 4 years ago, the Supreme Court refused to hear the appeal of a guy named Edward Hanasek. And Hanasek was a roadmaster for an Alaskan railroad company. He was in charge with supervising construction on railroad tracks. And when a contractor working under him accidentally ran a backhoe into a high-pressure oil pipeline, the contractor punctured it and caused a big spill in the Skagway River. Hanasek was sent to jail for a violation of the Clean Water Act. Now, at the time of the spill, Hanasek had the day off. He was away from the site. He was at home, and he didn't break the pipe. He didn't intend for it to be broken. He was at most negligent in the supervision of someone who worked for him. But he went to jail. Now, I should be clear. Nobody's saying that Hanasek and his company shouldn't have to pay through the nose for the damage they caused. They should. But to put the man in jail for negligence violates every historic principle of the criminal law. And it puts a great number of people at risk. When they dissented from the Supreme Court's denial of review, Justices Thomas and O'Connor said that the court's decision had the potential to, quote, expose countless numbers of construction workers and contractors to heightened criminal liability for using ordinary devices in normal industrial operations. And speaking of heightened criminal liability, right now there are 3 U.S. seafood dealers and 1 Honduran lobster fleet owner doing hard time in federal prison for importing the wrong size lobster tails and packaging them in clear plastic bags rather than cardboard boxes. They ran afoul of the Lacey Act, which is a federal statute that makes it a crime to import fish or wildlife taken in violation of any foreign law. Well, the foreign law that the U.S. government said they'd violated was a number of regulations in Honduran law. The U.S. government argued that these folks had broken Honduran law because some of the lobster tails in their shipment, 3% to be exact, were less than 5.5 inches long. Some of the shipment, 7%, contained some egg-bearing lobsters. And finally, because of this Honduran regulation, supposedly required them to be packed in boxes. Now, one problem with this theory of the case is that Honduras said the U.S. government was wrong about Honduran law. The Honduran embassy filed an amicus brief in the case saying the regulations were invalid and no laws had been violated. The Attorney General of Honduras and the Agriculture Secretary also provided evidence that this was the case. But in the interests of quote-unquote finality, the Federal Court of Appeals let the conviction stand. And because of that, Robert Blandford, Albert Schoenwetter, and Donald McNabb, 3 small business people with no prior criminal record, are now serving 8-year terms in federal prison. Their partner in crime, Diane Huang, a seafood importer with 2 kids, ages 6 and 10, she got off easy. She got 2 years, and she'll be out in July 2006. Finally, let me just touch on one more aspect of the problem that I mentioned at the beginning. one more way in which the criminal law has slipped its bounds. That's the use of heavy-handed criminal law enforcement tactics against people who haven't committed violent crimes. Now, a lot of people take a certain satisfaction in seeing rich and powerful figures like Martha Stewart or Michael Milken brought low. You know, a lot of people get this sort of cheap thrill, unfortunately, from seeing CEOs led around in handcuffs as if you know, they'd otherwise reach for the officer's gun and take a hostage or something. But it's unfortunate that people feel that way, because what they don't realize is that the system they're applauding can be and is being used against people just like them. Unfortunately, I have dozens of stories I could tell you about that, but as my time is growing short, I'll just limit myself to two. A couple of months ago, a school teacher named Hope Clark took a vacation cruise to Mexico. On her return, when the ship docked at the port of Miami, she got the proverbial knock at the cabin door at 6:30 in the morning. There was a team of federal agents there from Immigrations and Customs, and they cuffed her and dragged her off to jail. So what was her crime? Improper food storage. At Yellowstone National Park the year before, she'd left a bag of marshmallows out, and she got fined for it. Records showed that she hadn't paid the fine, and a federal judge in Wyoming issued a bench warrant for her arrest, which came up when she came back into the country. Well, Ms. Clark was put in a cell in the middle of the general population. It was her own cell, but it was in the middle of a wing of the jail with the general population, with male prisoners hooting at her and making obscene propositions. 7 hours later, in leg shackles, weeping hysterically, she was dragged before the judge. It turned out she'd already paid the fine. It was a paperwork screw-up. Now, you would think that if you were the prosecutor in this case, right, you'd be mortified. You know, you'd apologize to Ms. Clark and you'd drop the charges immediately without complaint. Well, you'd be wrong. Instead, the assistant U.S. attorney on the case actually argued with the judge, saying there was some discrepancy here and she ought to be forced to answer for it in federal court later. The judge, to his credit, said, "I think that 7 hours in jail is a sufficient punishment for leaving marshmallows out at a campsite." Now, it's much easier for outrages like this to happen today, in part because of a Supreme Court decision a few years back. 3 years ago, the Supreme Court heard the case of Atwater versus City of Lago Vista. In this case, soccer mom Gail Atwater was driving along and was pulled over by a Texas police officer for driving without a seatbelt. At the time, she was going less than 20 miles an hour. But in front of her crying children, a 3-year-old son and a 5-year-old daughter, the officer cuffed her with her hands behind her back, stuffed her in the squad car, and drove her off to jail. And oddly enough, he didn't buckle her seatbelt for her when he did it. Ms. Atwater argued, reasonably enough, you'd think, that this was an unreasonable search and seizure under the Fourth Amendment. But she lost. Because of cases like this and cases like the Hybel case that the Supreme Court handed down recently, which allows state governments to criminalize the refusal to identify yourself to an officer of the law, because of decisions like this, citizen police encounters, there's a danger that they're going to become a lot more confrontational and a lot more threatening than they ought to be in a free society. In a free society, the ordinary citizen minding her own business ought to be able to rest assured that she's not going to be handcuffed and humiliated by agents of the state. But increasingly, that's not the case. The criminal law is always supposed to be a shield, protecting ordinary citizens from predators. In too many cases, because of some of the developments we're going to talk about today, in too many cases it's become a sword that predatory officials can use against ordinary citizens. And when the full weight of the federal government comes down on a Martha Stewart, well, she has a lot of resources, and she's at least got a fighting chance. And that's not the case with most Americans. Well, we can talk a little bit in the question and answer session about how to start relimiting the criminal law. But I'm afraid this is another case where diagnosing the problem is a lot easier than providing a solution. But as hard as it might be for us to find solutions, it's really urgent that we start talking about how to relimit the criminal law, because it's an issue that goes right to the core of individual liberty and the kind of society that we want to be. Thank you.
We are now going to hear from Judge Andrew Napolitano. I do not think it is an exaggeration to say that Judge Napolitano is the most principled defender of the Constitution and individual liberty in the television news business. I have seen surveys that say that ordinary Americans do not recognize names like Antonin Scalia, David Souter, or Ruth Bader Ginsburg, or the other justices on the Supreme Court. The judges that ordinary Americans recognize are the ones that they see on TV, and their names are Judge Wapner and Judge Judy. Now, given that reality, I think everyone who cares about the Constitution and individual liberty should be deeply appreciative of the work of Judge Napolitano. Week in and week out, he conveys constitutional principles in interview segments that are sometimes as short as 2 or 3 minutes long. He's a great teacher and a great communicator, and I think he brings the Constitution and the Bill of Rights to life to millions and millions of people on TV each and every weeknight. The judge has now written a very readable book on the law for lay people. Again, it's called Constitutional Chaos: What Happens When the Government Breaks Its Own Laws. And we're delighted to be able to do our small part in bringing some attention to this wonderful book. Judge Napolitano has had a remarkable career. He earned his bachelor's degree from Princeton University and his law degree from Notre Dame. He was voted 4 times as the most outstanding professor at 2 law schools where he has taught constitutional law, and he is the youngest person in New Jersey history to receive a lifetime judgeship. After several years, Judge Napolitano did leave the bench to pursue a career in broadcast journalism. He is now the senior judicial analyst with the Fox network, and he is seen on the O'Reilly Factor and all of the other Fox News television programs. Would you please give a warm welcome to Judge Andrew Napolitano.
Thank you very much, Tim. Thank you for sharing your lunch hour with us today. I think it was my 2nd or 3rd day on the bench. I was assigned to small claims. You know, people will come in with a blouse saying the dry cleaner ruined it. It's 15 years old, but I still want $29 for it. You have about 40 or 50 of those cases in the morning and another 40 or 50 in the afternoon. I'm trying about my 3rd or 4th of them when a lawyer stands up and he says, "Your Honor, my client doesn't speak English. We need a translator." So I call the court clerk's office. There's no translator available. And I say to the courtroom, "Is there anybody here that speaks Italian?" which is the language in question. The little guy in the back raises his hand. He comes up. We swear in the translator. We swear in the witness. And the following is literally what happens in the courtroom. Question, lawyer to translator. Give the court your name. Translator to witness. What is your name? Question, lawyer to witness. Give the court your address. Translation, translator to witness. Where is your house? At this point, I say to this character, "I thought you said you could speak Italian." He says to me, "I can, Your Honor, but my English, she's not so good." In the courtrooms of the United States of America, unfortunately, there is little levity. We just heard horror stories from Gene, stories that are unfortunately all too prevalent in our society and which need to be publicized. I propose to speak to you today not about the criminal justice system, which is what I talk about in the first half of my book, but about the government's war on terror, which I discuss in the second half of my book. The American Constitution the American system of government with a written and popularly accepted Constitution, which shows and demonstrates the primacy of the individual over the state, is the greatest political achievement in the history of the Western world. Nowhere is the government's fidelity to the limitations imposed upon it by the Constitution and the guarantees of human liberty which it is required to honor. Nowhere is that behavior more sorely tested than in wartime. Sadly and lamentably, the present government, like every single one of its predecessors, especially those that has engaged in war, is seriously wanting with respect to the enforcement of the guarantees of liberty in the Constitution. Remember from basic high school American history, when we were colonists and the king was looking for cash, Parliament enacted, among many abominations, the Stamp Act. The Stamp Act required that for every document, whether it be a poster on a tree, playing cards that you would use in your home, a bank check to the extent they existed at the time, or a mortgage or a lease or a deed, every document, for it to be lawful in the colonies, had to bear the king's stamp. You had to go to a government office and buy a stamp. And that's one of the ways that the British government raised money from amongst the colonists. How did the British government enforce the Stamp Act? It sent soldiers to your home with the proverbial knock on the door, asking to see your stamps. How did the soldiers get into the homes of the colonists? The king addressed that problem. The Parliament enacted the Writs of Assistance Act. And a writ of assistance was a warrant so broad and so general, devoid of scope, devoid of subject matter, devoid of geographic limitation, that it literally allowed the king's soldiers to go wherever they wished. And commentators have referred to the writs of assistance as virtually self-written search warrants, because it was a document that would allow the soldiers to go as they wanted. The rest is history. We fought a revolution. We enacted a constitution. We added a Fourth Amendment. The Fourth Amendment prohibits writs of assistance. It condemns the concept of self-written search warrants. It specifically requires that before the government can come onto your property, whether it's to look for your stamps or your marshmallows or your children, it has to get a search warrant. And in order to get that search warrant, it must go to a neutral judge, state or federal, and present that judge with evidence which the Constitution calls probable cause. Simply, enough evidence to demonstrate that it is more likely than not that the target has engaged or is engaging in criminal activity, and the search warrant is likely to be fruitful. After presenting that evidence to the court will decide whether or not to sign the search warrant. For 200 years, Americans enjoyed that enforcement of the Fourth Amendment. We could sleep at night with a certain knowledge and security that if the government was going to knock at the door or break it down, it would only be after a judge scrutinized the government's efforts and specifically authorized it to do so. Comes now the Foreign Intelligence Surveillance Act of 1977, known popularly by the acronym FISA, F-I-S-A. FISA creates a super secret federal court. We are told it meets in the sub-basement of the Justice Department, but because we can't see the records of where it meets, no one knows where it meets. FISA authorizes the government to come before this secret court, and by demonstrating the existence of probable cause, not that a crime has been committed, but that a human being is an agent of a foreign government, authorizing then surveillance of that human being. Now, an agent of a foreign government could be an agent of a friendly government. It could be an employee of the government, not engaged in any espionage or spying activity. FISA, believe it or not, actually has a protection for civil liberties in it, because it limits the government's ability to use the information obtained from a FISA warrant for one purpose, and one purpose only, and that is to kick the offender out of the country. If, for example, a person is holding himself out as a journalist from a foreign government, and that person is truly a spy for that government, the information obtained from a FISA warrant cannot be used for any criminal prosecution. Why? Because it wasn't obtained with the true constitutional probable cause. But the person could be kicked out of the United States. In 1986, the Congress again tinkered with the Constitution when it enacted the Electronic Privacy Act of 1986. As I'm sure you know from the way the government names statutes, the Electronic Privacy Act has nothing to do with protecting your privacy. It has about as much to do with privacy as the Patriot Act has to do with patriotism. Nevertheless, the Electronic Privacy Act expands FISA so that the target need no longer be an agent of a foreign government, but the target could be a foreigner, a person not native to the United States. The other expansions of the ability of this secret court to give search warrants are for those engaged in organized criminal activity, whether foreign or domestic. And then the Congress decided to allow FBI agents, when the need arises in their own minds, and when surveilling a foreigner, to write something called a national security letter. Again, a government euphemism for an abomination. A national security letter is what the king authorized under the Writs of Assistance Act, a self-written search warrant. It took 200 years for them to come back, but back they came. Not because the Parliament of England and a king 3,000 miles away authorized them, but because our elected government in this city and the President of the United States signed the act, allowing FBI agents to write their own search warrants. The targets of these search warrants were intended to be financial institutions. Now, under the Electronic Privacy Act of 1986, if the government wished to examine the financial records of a foreigner or a person engaged in organized criminal activity, it would simply serve the warrant on the financial institution without going to a judge and demonstrating probable cause. What would the financial institution do? It would call up the person whose records were sought and say, "We received a warrant from the government for your financial records. We intend to comply with that warrant in the next 10 days unless you produce a document instructing us not to do so." You had time to call a lawyer. You had time to find out what the government was looking for, who the government was, what they wanted, and to challenge that warrant before a judge. You would argue whatever the facts were as to why the government shouldn't get what it was looking for. The government would argue against you before a federal judge. It wouldn't be the judge who issued the warrant, because the warrant wasn't issued by a judge. It was issued by an FBI agent. Either way, however, you had your day in court. The judge ruled either the FBI agent is right or no, this is the wrong bank account, or there is no even prima facie case here as to why the government should get your records. Comes now 2001, when the government enacted the Patriot Act. The Patriot Act is the most abominable, unconstitutional, congressional assault on liberty since the Alien and Sedition Acts of 1798 made it a felony to criticize the Federalist government in this city. The Patriot Act purports to legitimize the trade-off of human liberty for government safety. The trade-off is a ruse. Giving up liberty in return for safety not only violates the natural law, not only violates the reasons for which we have come together as a government, not only violates the principles of the Declaration of Independence and the Constitution itself, but it doesn't work. There isn't a single instance in American history where giving up liberty has brought us more safety. There is not one documented event in American history where the national security was impaired because some person in the United States insisted on their right to speech, or their right to privacy, or their right to due process. Well, the Patriot Act says, yes, the government can write those self-written search warrants. Yes, the FBI can do so. But if you receive a self-written search warrant, you can't tell anyone about it. You can't tell Fox News or the New York Times or the Cato Institute or even your spouse or your lawyer that you received a self-written search warrant from an FBI agent. Why? Because the Patriot Act makes it a crime to speak about what the government is pursuing you for. Wait a minute. Doesn't the First Amendment say Congress shall make no law abridging the freedom of speech? Never mind, says the Congress. The times are too perilous. The enemy is too dangerous. He's too slippery and too volatile. We can't allow people speaking about those we are pursuing. Oh, and those financial institutions, they can't tell you that they received a self-written search warrant as well. So now the government, without the involvement of the judicial branch, in direct violation of the Fourth Amendment, can go to a financial institution and obtain your records without you even knowing it. Comes as well the Foreign Intelligence Authorization Act of 2004, signed into law on December 13, 2003, a day where everyone in this room, a day in which everyone in this room will remember because of an event in human history that occurred on that day. The Foreign Intelligence Authorization Act redefines financial institution. Remember the Intelligence Act of '86? We can get the records from a financial institution. Remember the Patriot Act? We can get the records from a financial institution, and they can't tell you that we've sought your records. So the Foreign Intelligence Authorization Act purports to say, what is a financial institution? Well, you know by now it's more than just a bank. In addition to a bank, it is the following: a hotel, a casino, a restaurant, a bodega, a delicatessen, a lawyer's office, a real estate agent's office, and that great, wonderful financial institution in which we would all repose our wealth, the post office. So for the first time in American history, from the Patriot Act and the Intelligence Authorization Act of 2004, the government can read your mail before you do, and without you knowing it, and without the involvement of a judicial officer whatsoever. And if the government chooses not to prosecute you on the basis of what it learns from these, quote, financial institutions, here's the kicker: if you're not prosecuted, you'll never know that the government has obtained these records and documents about you. Oh, December 13, 2003, what happened on that day? Why was the Intelligence Authorization Act of '04 signed on that day? It was the day we captured Saddam Hussein. The government knew signing a piece of legislation like this would be buried in the newspapers and not even recognized until a month later. Later this week, the President will sign the Intelligence Reform Act of 2004. Don't believe it. It's not really the Intelligence Reform Act of 2004. It's the Patriot Act 2. Recall about a year ago, our now outgoing and then in full flourish Attorney General John Ashcroft proposed a Patriot Act 2, widely derided by liberals and conservatives alike. We don't need these additional powers. After all, Mr. Attorney General, since October 15, 2001, when Patriot Act 1 was enacted, not a single successful prosecution in the war on terror has taken place on the basis of evidence obtained from the use of the Patriot Act. Not one. So why do we even need a Patriot Act 2? And the proposals sort of drifted away. We didn't hear about them again. Well, we heard about them last week. Were they part of the original Intelligence Reform Act? No. Were they part of the Intelligence Reform Act that was debated by Congress? No. Were they part of the Intelligence Reform Act that was held up by the House Republican leadership? No. Where did they come from? They were added by the conferees, by the House and Senate conferees. These are additional powers given to the government and regulations imposed upon the judicial branch. If the government declares that that a defendant is a terrorist, it is presumed that the defendant is not entitled to bail. Wait a minute. Doesn't the Eighth Amendment say I have the right to ask for bail no matter what the government says I did? Yes. But under this act, the government does not have to prove that you are a terrorist. You have to prove that you are not in order to obtain bail. This turns the presumption of innocence on its head. Second, if a person is an alien and is deemed by the government to be dangerous, the person can be deported summarily, without notice, without trial, without appearance before any judge. Wait a minute. Doesn't the Constitution protect persons? Doesn't the Due Process Clause give guarantees to persons, not just citizens? Nevertheless, the Congress has enacted, and the President will sign, presumably later this week, this statute. Oh, and remember FISA. Remember how the target originally had to be an agent of a foreign government, and then the act in '86 said it could be any foreigner? They've changed it again. Now the target of either a FISA search warrant or a self-written search warrant need only be, are you ready for this? A lone wolf. What in the name of God is a lone wolf? Anyone the government wants to say is a lone wolf. A person acting independent of all others, not affiliated with or regulated by a foreign government or any organization whom the government deems to be dangerous. Why has the Congress engaged in a regular, consistent, systematic, inexorable assault on human liberty? Because it believes it is popular to do so. As Justice Scalia has said, never forget about legislative history. There's only one reason only, why anybody in Congress votes for or against any piece of legislation, so that they can get reelected. That is the only reason for the casting of any vote. Thus, there is a perception amongst the 535 who work on Capitol Hill. I say work. I can't imagine any of them read the Patriot Act. We know only 2 did, and one of them is dead. The guy who died in a plane crash, whose name is now escaping me, the senator from Minnesota. Wellstone. The other is Russ Feingold. Senator Feingold, of course, voted in favor of the Intelligence Reform Act of 2004 because he thought he knew what was in it, in fairness to him. He hadn't had a chance to read, because they didn't give it to him, the revised version that came out of the House-Senate conference. So there is this perception in the land of NIMBY, not in my backyard. It is not that we are giving up our liberty for our safety. It's that we are giving up their liberty, whoever they are, for our safety. In World War I, they were Eastern European Jews arrested by the thousands by one of General Ashcroft's predecessors, arrested and incarcerated without charge or opportunity to defend themselves. In World War II, they were Japanese Americans by the hundreds of thousands, and to a much lesser extent, Italian Americans, arrested by one of Don Rumsfeld's predecessors, arrested and incarcerated without charge. In the War on Terror, they are Arab American young men in their 20s without political assimilation or power or access. We need to demonstrate to the Congress that it is not popular or accepted to curtail constitutional liberties in the name of safety. It's wrong, it's immoral, it's unlawful, it's unconstitutional, and it doesn't work. It is the Constitution which is the supreme law of the land, and not the Congress. If the provisions of the Constitution are not upheld when they pinch as well as when they comfort, then they may as well be abandoned. Thank you, my friends.
Thanks very much, Judge. After listening to Judge Napolitano, you can appreciate the fact that on his book jacket he receives praise not only from Bill O'Reilly and Rush Limbaugh, but he also receives praise from Nat Hentoff, who's a columnist with the Village Voice. He says Napolitano speaks truth to power, including all presidential administrations. And I've read most of the book where he takes on the Clinton administration and Janet Reno, and as you can see, he pulls no punches when it comes to the Bush administration and Attorney General John Ashcroft. We're going to open up the floor to your questions right now. Before I call on the first questioner, I do want to make it clear, especially to the people who are coming in late, that both of these books are available for sale outside. And for the people who are watching on C-SPAN, you can get information on both of these books by visiting the Cato Institute website. Cato has published Gene Healy's book, Go Directly to Jail, and the judge has kindly allowed us to publish parts of his book in our latest newsletter, Cato Policy Report. It's the lead article by Judge Napolitano. So if you want to get a flavor for the book before you publish it, go ahead and visit the Cato Institute website, and you'll find both books at your local bookstores. Okay, we're going to take your questions now. I have 3 brief requests before I call on you. Please, when I do call on you, wait for the microphone to come down so that everybody here can hear your question. Secondly, before you ask your question, please identify yourself and any affiliation that you might have. And third, please keep your questions short so that we can get to as many people as possible. Yes, right down here.
Hi, thank you. Judge, insofar as the FISA warrants go, isn't it also true that the change was made that where in one of the changes that they made to it, or maybe when the Patriot Act was passed, is that it also included or changed the language that said before you had to be the primary function of the search. Primary was because the activity of the individual was primarily concerned that he might be involved in terrorism, and they changed that to read that he only that he does not have to predominantly that doesn't have to be the predominant reason, but just one of the reasons.
Actually, the Patriot Act removes from FISA the requirement of involvement in any terrorist activity whatsoever, and only mandates that you be a foreigner, which could be a person here on a visa, a student here on a student visa, a bona fide employee or reporter for a foreign organization. It removed the original limitations and safeguards in FISA. And you remind me of something I neglected to say. Remember, FISA prohibited prosecution on the basis of information obtained from a FISA warrant because the drafters of FISA were intellectually honest enough to recognize that the warrants were unconstitutional. The Patriot Act not only allows prosecution for information obtained from FISA warrants, it requires that the recipients of information from a FISA warrant give it to prosecutors.
Right here.
Thank you. I'm Peter Nelson with the International Trade Council. Lest we all leave here being very paranoid, I'm curious, who is orchestrating all this diminution of private rights? Now, the member of Congress is responsive to his constituents right after himself as number one, the party number two, and the United States number three. The constituents seem to be the bad guys in this. And where do they get their information? From the press. And so the question is it the liberal press, or who is keeping the attention on this fellow that just got lost his case, Peterson? For 6 months we've heard nothing but that. So people get their opinions from the press, and then they express it to the congressman, and the congressman enacts legislation that's responsive to their will. Who's supposed to look over the validity of all this? That's my question. I'm sorry it's so long.
That's okay.
Well, Gene can address better than I the Congress's history of enacting legislation that takes behavior once deemed ordinary and moral and making it criminal on the federal scale. From my own point of view, I don't think there's any grand conspiracy to keep Peterson, California versus Peterson, on the front page, and to keep people from reading the 600 pages of the Intelligence Reorganization Act of '04. The 9/11 Commission, chaired by my good friend Tom Kean, the governor of New Jersey, who appointed me to the bench, captivated the public's interest by the proposals that it made for a reorganization of the intelligence community. It's beyond me how a problem of bureaucracy can be cured by adding another layer of bureaucracy. Nevertheless, this act passed by overwhelming numbers in the House because I think, and the Senate, members of Congress perceived that the public wanted something done, even something cosmetic.
Do you want to say something on that, Gene?
Sure. Well, as to why why the criminal code keeps on expanding, I think a lot of it, and why people accept it, I think it's sort of a perfect storm of motivations from people on both sides of the aisle that has just sort of led to this reflexive criminalization of things. And I think people accept it sort of because of the other guy phenomenon, sort of similar to what Judge Napolitano was mentioning. You always picture somebody else ending up in the clutches of authority, and you have a reflexive notion that well, if this person is doing the perp walk, they probably deserve it. So I think it's a phenomenon that is underappreciated, and I think more people need to understand that so when the courts stop enforcing constitutional guarantees, when Congress has a knee-jerk tendency to add criminal provisions to anything it thinks it's important, people really need to recognize that this, over the long haul, has the effect of a society where everything can be a crime and anyone can be vulnerable.
Yes, right here.
Don Ernstberger with Don Ernstberger.
And just speak up.
Yeah, Don Ernstberger with Congressman Dana Rohrabacher, who voted against and spoke against Patriot 2 last week. We were amazed when we tried to read through that. We had about maybe a day to read through that document, and we were struck by the degree to which what we are calling the camel's nose under the tent technique, where they're taking things that were in Patriot 1 that were sort of suggested as, well, don't worry, we've got these safeguards. And in the Patriot 2, they pull up the safeguards. Now, the one they didn't mention was the sunset provision.
Right.
There's a number of places we found where the sunset provisions, which were sold to the American people as temporary measures that all sunset, they're starting to strip them out. And I'm wondering if you've noticed some of those sunsets.
I have, and you are 100% correct, and that is an essential part of the argument that we're making today. One of the ways that Patriot Act 1 was sold on the Congress, and remember, there was no debate, there were no public committee hearings. Passages of that were added at 3:15 in the morning, printed at the government's printing office, and members of Congress had to vote the next day. That's why only 2 of them read it. It's 450 pages long, and it doesn't read like a novel. It reads like in change and to or, remove this semicolon, remove this underlined. It's very, very difficult to read. But one of the sales techniques that the Justice Department used was the sunset provision. A sunset provision establishes the expiration of a portion of the Patriot Act with the passage of time. So about 5 sections of it are to expire on December 31st, 2005. One of those sunset provisions also had what's called a trigger. A trigger sunset provision allows a single member of Congress, the courageous Congressman Rohrabacher, Congressman Ron Paul, guys that are not afraid of the leadership, to ask for debate on the subject matter of the sunset provision. The trigger requires that debate occur by a single member of Congress asking for it. The bill that the President will sign next week removes one of the sunset clauses and removes the trigger.
Okay, let's go up in the back, way up in the back, or on the aisle.
Raul Kohlberg, an independent researcher. I'd like to ask Mr. Healy, with regard to the cases that he was citing, if he can give us, as it were, the other side. What were the justifications in the Hanachek case for putting a man who wasn't even on the job in jail for the activity? What happened with the soccer mom and the marshmallow lady that was used to justify? Were these as outrageous as the acts, or did they seem to make some sense to a judge or others at the time that these activities took place?
Well, in the Atwater case, there really is no other side. I mean, if you read the Supreme Court opinion, even the majority that found that this wasn't a violation of the Fourth Amendment calls what Atwater was subjected to a pointless indignity, and they sort of berate the officer for doing this. So in that case, there really is no other side. But it's an interesting question, because in some of these cases where you wonder, why in the world would they send these people who violated a couple of regulations in Honduras that apparently Honduras doesn't even consider valid? Why were they sent to jail for 8 years? And sometimes it's difficult to get the backstory on some of these cases, but there is a suspicion with many of them that there's something going on where there's a reason why the person was targeted. In some cases where there's a guy, John Rapanos now, who's a Michigan real estate developer who is facing 10 months in jail for moving dry sand around on property that's 10 miles away from the nearest navigable water of the United States. In his case, He was he got in some altercations with the local EPA and with the state and with the federal EPA, and refused to fill out any more permits. He says, my land is basically dry. I'm moving, dry earth to another dry part of, I don't have any wetlands here. So in a lot of these cases, you've got people that have angered somebody in a position of power, and this points up, when you've got this overbroad criminal code. And you've got all of these potential statutes that can be invoked. I mean, it points up the problem that Justice Jackson referred to, which is you've got a case where prosecutors can pick the people that they think ought to be targeted rather than offenses that ought to be prosecuted.
Let's stay in the back, on the aisle there.
Judge, my name is Mark Lerner, and my Christmas shopping was disturbed over the weekend when I read the latest Cato policy report and the story about what Janet Reno did to that poor couple down in Florida. And I was just wondering why there wasn't more outrage when people learned. I'd like your view on why there was an outrage when people learned of what she did down there.
The questioner asks about former Attorney General Reno's activities as state's attorney for Dade County, Florida, in which she made a national reputation for herself in her own mind as a protector of children, in reality as a persecutor of those whom she perceived as harming children. There's a chapter in the book about her activities in prosecuting people who ran daycare centers. And extreme examples of prosecution, the most notorious of which involved a Miami police officer named Grant Snowden, who was ultimately freed by the 11th Circuit Court of Appeals because it found that Reno used hypnotized testimony against him. The questioner asks why she wasn't criticized at the time. And Gene Healy knows the answer to this better than I, but I'll give you my view. In every age there is a favored crime. That is a crime for which the public has been so whipped up into a frenzy that the mere accusation against a person of having committed the crime is tantamount to guilt in the public's mind. And when the public is in that kind of a mood, it will overlook constitutional violations in deference to the swift, draconian prosecution of the target. And we did live through such an era with respect to the prosecution of owners of daycare centers allegedly harming children. Many of whose convictions were overturned, some of whom were not and are still in jail.
Yes, right down here.
I would appreciate if either of you would comment on the recent Washington State Supreme Court ruling that parents cannot eavesdrop on their children's phone conversations, and is this a violation of the Constitution? How will this affect a kid who may be involved in a killing, a gang rape, drug dealing, or any kind of illegal behavior? And if it's okay, do you think it's okay? Thank you.
The Washington Supreme Court opinion, which is a unanimous opinion, is a construction and interpretation of a Washington statute, state statute. It is the literal reading of that statute. I consider myself a strong defender of the right to privacy, but I was raised in an Italian household. If you think my parents didn't know absolutely everything I did in that house, my own house would be managed the same way. It is a violation of the obligations imposed upon the parents to maintain the welfare of the children, not to allow the parents to know what the children are doing. In this case, it was truly a child. She was 14 years old, and her felonious boyfriend, who beat up an old lady and stole her pocketbook, was 17. Unfortunately, I don't see that result changing. It's the highest court of Washington interpreting a Washington statute. The federal courts, I don't believe, are going to get involved, and he was acquitted as a result of this, or at least a new trial was ordered. But it's the state interfering with the parent-child relationship.
Yes, over here.
Thank you. My name is Dan Rosenthal. I have two questions for Mr. Healy. The first question is, one of the things that you had, when you would address these problems where the criminal code is expanding, one of the solutions is to decriminalize and potentially place these as civil torts. But in other lectures for Cato, argue that civil torts are running out of control and that we have too many civil torts now litigated. So if we adopt both approaches and reduce the criminal code and reduce the civil code, really the answer would be just the total lack of accountability for any of these things, whether or not they're criminal, to decide. I wonder if you could address the consistency between those two philosophies. The second question is that instinctively I think that one of the reasons that the criminal code is expanding is because the complexity of our society is expanding, and that certain crimes like identity theft or theft of cable lines didn't exist before there were cable lines. And I would think that that would be a major factor in increasing the criminal code. Please address that. Thank you.
Yeah, I mean, we've certainly published a lot of things that are critical of some of the things that the plaintiff's bar has done, or some of the things that the state's attorneys general have done, you know, in regard to tobacco and Medicaid. We've criticized junk lawsuits, but I mean, I think it would be a mistake to take that criticism as somehow being opposed to a tort system. You know, I think legal scholars at Cato all view the tort system as you know, essential to a free society and a way of making people whole. So I don't think there's any inconsistency there. I believe your second question was about, is society getting increasingly complex, and does that require some new crimes? Well, I don't.